And because Chandra Saha has produced, he himself was a voter, my lord, in 1966, along with his father. My lord, I would like to Annexure 9, my lord. This was the notice of foreigners tribunal to the petitioner. And the petitioner was named only Govinda Saha in the FT case, in the reference. His name, Chandra Saha, was not mentioned by his wife. And therefore, notice could not be served first on the petitioner. My lord.
Who is Sandhya Rani Saha?
I beg your pardon, my lord.
Who is Sandhya Rani Saha?
Sandhya Rani Saha is the second wife of Govinda Saha, my lord, alias Chandra Saha. And she is a lady of Lanka. This Chandra Saha, in connection with business,
But
with
there
his
are
father,
three.
he was
But
in
there are
Lanka.
three voter lists of 1989, 1993, and 2005,
Yes.
where the Sandhya Rani Saha's father's name is Yogesh Saha.
Govinda Saha, my lord. And the father's name of Govinda Saha is Yogesh Saha. That is also another problem, my lord. That they, Yogendra and Yogesh, they confuse it, my lord. Sandhya Rani Saha's father's name is Yogendra Saha of Lanka, and Govindra Saha's father's name is Yogesh Saha of Jhargaon under Jagrut police station.
Please show us the exhibited documents. Yes, Verma, there are 4 witnesses. We have not been able to follow them. Because of these names, we have not been able to follow the evidence of DW 1, 2, 3, 4. So that is why we gave you the file.
We're just going
Ha,
to
ha.
check.
This Sandhya Rani Saha, my lord, has got one ration card from issued by Deputy Commissioner's Office. And in that ration card, my lord, then the name of Chandra Saha and Govinda Saha both are mentioned. It is Annexure 7, my lord. The learned tribunal said that Govinda Saha is not the Chandra Saha. But Chandra Saha claims that my name is also Govinda Saha and I am the same person. Only that thing, my lord. Other documents are all right.
Again, he says his name. In the trouble, I think it should be a shame. This is something.
তুমি এটা কাম কৰা মেনশন মোক দি দিলে তোমাক মই পাছত ঠিক কৰি পেলাই দিম কাৰেকশ্যন কৰিম অঁ 11th year আৰু নাই কিন্তু হা এই যিটো এলাউ কৰিব এই জাজমেণ্টটো এলাউ কৰিব হা ডিসক্লোজ কৰি দিলে আৰু
He says to go something, go with those is his name. A white rope and one to do. That is DW2 full mark six. DW2 shows it. Transition up in here. Written statement.
Which page is your written statement?
Written statement. Douglas from this
Your written statement.
statement.
Hmm?
Written statement. Douglas.
Written statement, I have not enclosed, my lord. It is in the original record, madam. Application number.
You will show it to you. You will be confused with it.
No, it will be the-
You will be so ashamed. Second. $74 na? Birthday na? Who is she? Seven, please. Page number. Page number 7, page like. Translation of same. PW8 of the Nikki. All of this. Page number. Page number any issue.
Cover is anyway.
Statement is also, proceedings before the.
Yes, Mr. Das.
Yes.
Yes, what do you have to say?
Well, this is Chandra Saha was born actually in Guwahati, Malot. And he came to Jagiroad with his father, and they purchased land there at Jagiroad, Jargaon, and settled there permanently, my lord. Still they are here. Thereafter, my lord, in connection with business, he with his wife and parents went to Lanka for some years, and they did some business there. And in that Lanka also, his name, his father's name was recorded in voter list, my lord. Thereafter, again, after 6 years, they came back to Jargaon, Jagiroad, their original place. At that time, he married another lady of Lanka, my lord, and her name is Sindharani Sarkar. Now, he was living at Zagreb. This Sindharani Sarkar gave birth to 3 children, my lord. And when these 3 children were become a little bit bigger, there was congestion in his family, and also there was some sort of disharmony in the family, my lord. So he took a rented house at Soto Harbour of Nagaon town and kept his second wife there with the children, my lord, for proper education and peaceful living of his second wife. And when she was there, Sakshandarani gave the name of her husband as Govinda Saha when his name was recorded as a Bhotari at Sudhaivar my lord. But actually his name is Sandraha Saha. My lord, our Hindu people, especially Assamese and Bengali people, they have got 2 names, my lord. One is secret name, that is known as Gupta, and another is calling name, nickname, that is Bekta. I also have got, my lord, 2 names. One of my name is Dibba, that is secret, and Bipin Chandra Das is my Bekta. This nickname, calling name, my lord. Now, all the Hindu people have got that type of name, and usually their name, which is Gupta, my lord, that is related to the position of the planets in the
I don't know,
solar system, my lord.
For quite some years, I know Ms. Verma. I have never heard of a secret name. Mr. Sharma also here.
My lord, I do not know whether Marwari community has got this Gupta name and
No.
Bekta name. But we
I
have
don't
got
know.
it, my
So
lord.
far as I understand, Mr. Sharma also is deep into this religious activities. He does it. Yes, you still do the religious activities daily. He does it.
All documents are all right, my lord. There is no doubt. Here the documents show that he is the same person.
Because at times I hear this, what you call Vishnu Sahasranam. Secret name is not mentioned. It is not there in the secret name of any gods and goddesses not recorded in at least 4 Puran I have read. Uh, 4 Puran which I have read is Gita Mahapuran, Shiv Mahapuran, then Markandeya Puran, and one more. I have not heard about secret name of any gods. So here we learned that secret should not be spelled out to the wife. Wife must not know the secret. From here we learned that. Yes, but still you see the documents are not matching up. Any document is known, none of the documents match.
It's not.
Documents
Documents not matched.
Hmm?
Documents not matched. In his name. The person doesn't match.
Because you see,
Well,
Mr. Das,
Yeah.
why you see, you know why I am saying so, why I refer to the religious books, and I give an example of Ms. Verma and Mr. Sharma. You see, what I said was just out of the blue. Neither I knew about the names of Mr. Sharma and secret name, if any, of Mrs. Verma. But you see, why I'm saying so is your own affidavit sworn on before the Foreigners Tribunal. This is in the record of the tribunal is one affidavit at page 30. I'm just sending it to you. It does not refer to a secret name.
It's chapter.
It refers to a nickname, but it does not refer to a secret name.
It's chapter. It is 9 again. You can please.
I was just dramatizing. This is page 30.
Yes, Lord, but I have reading. ইয়াতে এসবিটি ফিটত আপোনাৰ তাত আছে তাৰ মানে ইয়াতে দুটা নাম দিছে নো সিক্ৰেট নেম বুলি একো লিখা নাই দ্যাট ইজ ইয়োৰ সাবমিশন
well, that is only here mentioned as nickname. But nickname is the calling name, my lord.
Nickname is a
The secret name is kept secret such that other persons cannot influence him by magical power. For that reason, that name is not secret, my lord. Actual thing is that.
I don't know.
But here it is not mentioned, my lord. Only in the horoscope it is written Gupta name and Vector name, my lord.
I'm not sorry, I'm not aware. And possibly, Mr. Das, you have more experience than us. What we don't know cannot cannot come into the order. It cannot form a part of judgment. You know it more better than us. Mr. Das, will come back to you. Just here, Miss Verma, and then whatever queries we have, we'll ask you. Yes.
Lordship, since all the documents are there in the record, Lordship, I had just brushed through them. The additional written statement, he has stated, he has annexed only two voters list. One is 66 and one is 1971.
Where?
With the-
Where?
In the records, Lordship. Because in his petition, there's nothing except for the
Yes, yes.
so, opinion and some documents which
Yes.
are. Lordship.
Exhibit 1 is a voter list of 1966.
Yes, Lordship.
And
The-
then Exhibit 2 is 71.
71 with the first wife, and after that it is 2005 and 2010 with the two wives, and it has been marked D. And at the same time, he had his name in two constituencies, which is not permissible under law, Lordship.
Can you identify those two voter lists?
Lordship, I couldn't find it there, but it is here, Lordship.
It is referred in the judgment.
Yes, it is there, Lordship. I will just bring Lordship there. Page 43, Lordship.
Hmm.
Page 43.
Of the judgment.
Yes, Lordship.
Yes, there it is mentioned, but I wanted to identify the documents.
It would be there, but it's in vernacular, so I had some difficulty finding, but I could
Okay.
find some, Lordship. Thirdly, the proceedee, Lordship, if Lordship comes to this, and even in the starting at
Just a moment.
page 36 also.
The full action.
Nineteen 66, Lordship.
Yes, Rama will send you these records
Yes, Lordship.
because we have not been able to locate voter list of the same year from two different constituencies. Because
Won't be of the same year, Lordship. Because Lordship, what I'm trying to show Lordship is the first 66 voters list is of Jhargaon, where he states that he was born there. But in one of his evidences, the children have stated that he was born in Kharguli Uzan Bazar. That is also there. It's quite confusing, Lordship. And then the 71 voters list says, Lordship, if Lordship comes to the 71 voters list, it says Yogesh Chandra Saha father, page 19, Lordship. Renu Bala is the mother and Chandras is the proceedee. Father is Yogesh. If Lordship now turns to page 22, Lordship.
It is 21.
2005.
Yes, Lordship. Here, the petitioner's father is Yogesh Shah, his mother is again Renu Shah, but the husband's name is Chandra Shah. And
Alright.
Sandhya Rani Shah's husband becomes Yogesh Shah.
My
The
lord,
father becomes
I want to clarify, my lord. In the original one, the names are different. While it was typed by the clerk, my lord, in the English type copy, my lord, the names are written with different, my lord. The original certified copy is there, my lord. It is 5A, and correct names have been mentioned there. That is the original certified copy, my lord.
So, Lordship, there should be a cost for wrong translation also. Because I'll go by what is before me,
No,
Lordship.
correct. But Mr. Das has clarified, we'll go by his version.
It was a little bit my fault, my lord. I ought to have gone through all these things. I did not verify.
It's okay, we accept your.
Mistake will be there. But in the original, my lord, it is names are correctly
So,
mentioned.
Lordship, we'll look at this. This is of Jhargaon and the first is of Morigaon, Lordship.
Correct.
So there is and then the in between 71 is of Lanka.
Yes.
So the second wife registered her husband again in Nagaon Lordship, but he was the first voters list with his first wife is of Jhargaon. So his name figures in both the voters list at different point of time, Lordship.
2005,
2005, Lordship will see.
the
But the original. Bible says, my
Bokuli
lord.
Saha is the
That
wife.
copy is of-
Yes. And Lordship, written statement, the first written statement does not match with the second written statement. In his first written statement filed in the year 2013, he has not stated any facts. If Lordship will look into the first written statement, Lordship, there is no mention about his nickname also there. Over a period of time, he has tried to improve his case, Lordship. 2013 written statement is there.
My lord, in this case,
Just a moment.
no only thing on this to be.
Just a moment.
Maybe important for Thank you, Thomas. Arbitration. Yes, Lordship.
So that's we don't find you have a case because of the fact that there are two in the written statement or additional written statement and in your evidence. You only say that you are always the resident of village Jhargaon. You have not referred to any other village where you are staying. So therefore, your name appearing in a different different constituency. Resultantly, your evidence of one of your wife will not be acceptable. You never said that you are residing somewhere else.
His village name is Jargaon, my lord, of Jagatpur division.
But then the other evidence will fail. For Jhargaon, you are referring to 66, what do you call,
What does this, Lordship?
what do you call, 6671, 2005, and 2010 voter list. In 2010, you are at village Choto Haibargaon.
That is where he was marked D, Lordship. And in between, no voters list, no explanation. And by his submission, he said that he had to separate the two wives to maintain peace and harmony. Then again, both the wives' names comes together in 2010, Lordship.
But the father's name, husband name differs.
Different, Lordship. And Lordship, in his written statement and evidence, though he has written he was born in the same village, Jhargaon, but in his cross he gave up. He said his father was a resident of Kharguli and he was also born in Uzan Bazar, Kharguli, Lordship. So there are contradictions, complete contradictions in his own submissions, Lordship, where he was born, and the WS has no mention of his brothers, sisters, grandparents. A very vague WS has been filed, which does not help him at all, Lordship.
And Mr. Das, your age also does not tally. The voter list, the explanation given of your age and the voter list of 1966 does not match.
These are different. 1966.
Yes, my lord, age is little bit different.
48, he states
Also
he was
wrongly
born in
mentioned.
48, but the voters list are from 66. If he was born in 48, Lordship, he would have 66, Lordship, 48 and 66.
Well, his school certificate is there. It is school certificate shows that he was a resident of village Jargaon and he studied in Buraburi High School at Jagarut before 1971, my lord. And his name is Chandras, his father's name is Yogesh Chandra Saha. And if he can prove that he's the Govinda Saha also, then all documents are all right. Because he himself is a voter of 1966 and then 71. He now was at about 78 years, my lord. This Annexure 7 also shows that Govinda Saha and Saudra Saha is the same person.
Shankar Saha, this birth certificate also again has an erasure. There is some correction made.
Nivedan's sons who have appeared as DW, Lordship DW3, they also do not have a voters list with their father.
Some portion corrected. Two different things. This is it is design.
You know?
Some portion son of some portion. Eraser is there. Secondary main name to
Mr. Das, anything in reply? Hmm?
Controversial.
Name correction, name and is. Release. Right, like I'm going to put it. Next.
I think it is wrong.
50.
No.
50.
Is that 270?
50.
68.
50.
$68. Okay. Put on 1371.
Mr. Das, anything in reply?
Well, only thing is to be seen, my lord, here in this case, whether Govinda Saha and Chandra Saha is the same and one person, my lord. Now, in respect of age of Chandra Saha, my lord, he stated that he was born in 1948 and according to that, his age should be about 18 years into 1966. But he had given his age that in the 1960 voter list, his age is mentioned as 26, my lord. Now, distinguished my lord, this age discrimination in age in no way shows, my lord, that this Chandra Saha, who has claimed to be 48, want to be 48, is not the Chandra Saha of the voter list of 1966, my lord. This document shows that, my lord, he was in India and in 1966. This discrepancy is in age, my lord, cannot prove that he was not in India in 1960. What we require, my lord, as per Section 6 of Citizenship Act, 6A of Citizenship, whether he was in India before 1966, my lord.
Yes.
If only that point we can meet, my lord, by documents and oral evidence, then I am to be declared, I am to be treated as a citizen of India, my lord. In the judgment, my lord, in paragraph 20, the learned member has confused certain things, my lord. He has mentioned that he is a foreigner who, and the last line, my lord, he is a foreigner who entered into India from the specified territory of Bangladesh on or after 25th March 1971 stream without any valid document. Now, there is no record, my lord, there is no proof or anything mentioned in the reference, my lord, that he entered India after 25th March of 1971. Now, it is mentioned that he is a foreigner of 1971 stream. Now, if 1971 stream, my lord, he would have got the right to get himself registered, my lord. Now, dear my lord, as per Section 6 of Citizenship Act, there are three streams. One is pre-66, one is 66 and 71 stream, and the third one is post-71 stream, my lord. And the post-71 stream foreigners are to be, they are treated as illegal migrants and they are liable to be deported. And the persons who entered India between 66 and 71, my lord, they are foreigners, not illegal migrants, and they have got the right to get themselves registered as citizens of India, my lord. Only thing is that they will lose the right of franchise, right of voting for 10 years only, my lord. And if the document shows that he is a man who was in India before 1966, then he is to be treated as citizen of India, my lord, as per 6A of the Citizenship Act, my lord. There are so many discrepancies, my lord, in age, in name also. But what we have to see in overall, whether the overall evidence, overall consideration of the entire material on record shows that he is a person who was in India before 1966, my lord. And in this case, he is also to show that it is also to be shown that Govinda Saha and Chandra Saha is the one and same person, my lord.
Yes.
Divana. Mohammed Fakhruddin.
Counsel for the petitioner. Respondents are there.
I would like to state two judgments.
Mr. Islam on behalf of the IID.
Passage only.
Arguments concluded, judgment is out. Yes. What are the citations you want to give?
Yes, Lordship. One is that the proceedee has to disclose all material facts in his possession at the first instant itself in the WS. I'm relying on WPC 3071 of 2016, Lordship.
Name of the parties.
Jainuddin, Jainal, Jainul Uddin versus Union of India, Lordship.
Is it reported?
Yeah, Lordship, I will have to check, but yes, Lordship, I have this here. It was decided on 3/4/2018, Lordship. No, OSO, sir, it to WSO or DSO. Lordship, I'll give the paragraph, Lordship. It is a long judgment, but it is not numbered, which we have. Then, Lordship, I would like to rely on Basiron BB. It is reported in 2018, 1 GLT 372. Para 32 Lydia.
Give the citation again.
Basiron, Basiron, Basiron BB, BIBI 2018, 1 GLT 372. Paragraph 30, Lordship.
This is on what point?
This is on documents, has to be read as a whole. I can just, it's a short paragraph. May I read it, Lordship?
Yes.
Reliance placed in the case of Abdul Matali, alias Matalib, can be of no assistance to the petitioner inasmuch as it has already been clarified by this court in previous decisions that the said decision did not lay down any law and was a decision confined to the facts and circumstances of that case. Regarding discrepancies in the voters list which the petitioner contended were not her creation being entered into by officials of Election Commission and therefore should not be used adversely against the petitioner, such contention is without any substance. The voters' list were adduced as evidence by the petitioner herself to prove her case that she was not a foreigner but a citizen of India. Petitioner cannot insist that only that portion of the voters' list which are in her favor should be accepted and those portions going against her should be overlooked. This is not how a document put forward as a piece of evidence should be examined. The document has to be appreciated as a whole. And Lordship again, I would like to rely on. And the state emblem is used, Lordship. Oh, that evidence also goes away. State emblem, Lordship.
State emblem in which document?
The Gao Panchayat, Lordship. There is in the record, Lordship, there is a certificate of the wife. Because the records are not in the petition, Lordship, very difficult to find out. Another very important citation which I want to cite, Lordship, is that is long stay and enlistment of name in voters list is no proof of citizenship, Lordship. That is reported in WPC 4512 of 2016. Mohammed Fakhruddin, Fakharuddin versus Union of India. Decided on
What is the name? What is the name? Please give again.
Mohammed MD Fakhruddin, Fakharuddin.
One word or two different words?
It's one, Lordship. Versus Union of India. And this was decided on 28/2/2018, Lordship. There's a just short one paragraph which I'm relying on, Lordship. That is a discrepancy in age here and there may be acceptable, but consistent discrepancies in the date or year of birth, coupled with other material omissions and contradictions, would certainly raises grave doubts about the genuineness of the narrative presented by the petitioner. These are the few judgments, Lordship, I would like to love. And again, Lordship, the most common one which we reply every day on the writ of certiorari, Lordship. That is reported in 2023 SCC Online SC 996. Central Council of Research in Ayurvedic Sciences. Versus Bikartan Das and others, Lordship.
Okay.
Thanks.
My lord, I would throw one thing, my lord. My lord, these foreigners cases, my lord, how to dispose of these cases by tribunals? The guideline is given in Foreigners Tribunal Order of 1964, my lord. According to that, Foreigners Tribunal are to try the cases as summary trial, my lord. In summary cases, the tribunal need not record the deposition of the witnesses verbatim. The tribunal can write only the substance of the deposition, my lord. And the tribunal has to consider all the matters, and on the preponderance of probability of the recording of position of all the documents. If the tribunal comes to the decision that the possibility is that he is a citizen of India as per evidence available on record, then he is to be declared valid as foreigner, my lord. That is the guideline of central government, my lord, in Foreign Tribunal Order 1964. My lord. So those things have to be similar. And one or High Court also, my lord, I forgot the reference, but you will also remember it has been mentioned that on preponderance of probability, the citizenship is to be considered. If all the documents shows that he is not a foreigner, he is not likely to be a foreigner, but he is a citizen of India, the probability can be shown, my lord, that he has to be declared as a foreigner in the Western country.
It was. We'll take a short break and come back again.
नहीं मुझे ना आपको लोगों ने की और
Order is paid 56, my lord. And 2019 judgment, my lord. At this stage, I am paying for call for my calcium and call.
Page number
56, my lord.
56. Okay. Mr. A.K. Azad, counsel for the petitioner. All the respondents are there. Mr. Islam on behalf of Mr. A. Ali. Opinion is at page 56, 29/6/2019. Notice extra copies within today's call for the records. The prayer for bail shall be considered on receipt of records. Give a date after 4 weeks, fixed date.
In the meantime, my lord, if arrested, shall not be deported, my lord.
No, Lordship, not now, Lordship. Let the
Should not be
records
deported.
Not deported.
Yes, shall not be
Lordship, there
deported.
is now a drive going on for the declared people. If Lordship puts that stricture, then again it becomes difficult, Lordship.
But then she can't be deported. That's since we are there. In the event the petitioner is apprehended, in the meanwhile, she shall not be deported out of the country without order of the court.
23rd of June.
Sorry, date to DDR, no? 23rd. Finance. Adjourn motion 9. 409, 450 adjourn. Need to adjourn. ডেটটো আছে নেকি চোৱা 4 to পিছত আছে 4/9 ন
Oh.
ৰেকৰ্ডটো আনিবা নেকি এবাৰ অকণ চাই ল'ব বহা
Item 4 for admission. Please, your lordship. My lord, this representative file selling the impugn ordered judgment dated, my lord, 12/3/18 versus pass next time, my lord, 22, page number 119 or so.
What is the date of your opinion? Do you have an extra copy? No.
Lord, 23/18.
Date of opinion
23/18.
23
2003.
23 2018. This one a file on now. No.
My lord, the
Opinion is at which page?
my lord, start from page number 119 or so. Right. The tribunal held that he could not prove that his father came before 66 or after my lord 66 to my lord 71. Otherwise she was born on lordship 10/5/83 lordship
10/5.
1983 my lord. But as per the opinion of the tribunal, she could not prove her father that he has come before 1966 or after my lord 66 to 71. Lord. He had exhibited the sale deed of 1968 lordship of his father, my lord. Again, my lord, 72 lordship. And moreover, my lord, she had annexed the my lord, it is the evidence.
What
of
is the name of your father?
Sunil lordship.
Anil Mandal.
Sunil lordship.
Sunil.
Yes, lordship. I have annexed the sale deed lordship as annex of 5 lordship, page number 33 lordship. He had purchased the land in my lord Nagaon lordship, along with his brother lordship. Moreover, my lord, mother of the petitioner also, my lord, Indian citizen lordship. And she also and exhibited the my lord documents showing their my lord family tree also lordship. But that was not
Where is it sale deed?
my lord, page number 30. one honored lordship. Sorry, lordship, 33 honored lordship. Type copy is the, my lord, 33, my lord. Wherein father of the petitioner is number 3, my lord, Sunil Mandal lordship. Original, my lord, page number 36 honored lordship. Vernacular. My lord, same was exhibited at exhibit 1 in the tribunal lordship.
Have you annexed the Javabandi here?
Lord, I have and just annexed the sealed it only, Lordship.
Hmm?
Who sealed it? No, my lord. Only
Pardon me?
who sealed it only, Lordship, and we have not annexed the Jamabandi yet.
Okay.
But it was exhibited in the tribunal, Lordship.
Mr. Pang, you're looking at the LCR. Please see Exhibit 2A. What is that? Just, just pass it on for the time being. Yes. And it appears that there is some incorrect construction by the tribunal. You will find down below, Exhibit 3 is a copy of what do you call printout certified copy of the printout copy of the Jamabandi. Down below, Exhibit 3. Not this, there's one more. No, below that, a bit below that. Not this, below that. Skip a few pages.
Exhibit 3, my. Exhibit 3A. 3 I got it. This is 3A.
This is 3.
A, man.
No, 3.
Wait.
This is 2A.
3.
No, again, down below, you'll again get a certified copy of Jamabandi. A printout copy. I don't know whether it's certified or not.
Exhibit 3.
Yes.
Exhibit.
Yes. Is this an exhibited document? I did not check it.
Material exhibit number 3.
Material exhibit number 3.
Material exhibit.
So here you see in this, come to page 123. Paragraph 10. Exhibit 2 is a sale deed, but proceeding has not produced any document regarding mutation of the name of Sunil Chandra Mandal that has been rejected. So therefore, there are two documents, 2A and 3, which discloses the name of Sunil Chandra Mandal.
It is Patal Mondal. This is Batal Mondal. But the better of the here, Sumit Mondal is not there. Exhibit
This
3.
is Badal Mandal.
Yes.
Brother of the petitioner's father also.
Hmm?
Brother of the petitioner's father also.
But this Badal Mandal was.
No, no, he was also examined as DW5 lordship. Sorry, PW5 lordship.
Badal Mandal.
Yes, lordship.
Where is his evidence?
My lord, I have annexed as annexer 21F, page number 114 onward, lordship.
114.
Yes, lordship. My lord, name of Badal Mondal is there in the my lord sale deed lordship in exhibit 1 lordship, along with his along with the father of the petitioner.
Exhibit 1 is not the document for this Exhibit 3.
Yes, lordship.
Does exhibit the sale deed of this land contain his name?
My lord, annexer 1, my lord, father's name of the petitioner also recorded, my lord, and Badal Mondal also recorded, lordship, as brother.
No,
of-
not one.
Except
This Jamabandi is of
I'm not-
72 sale deed. Whether 72 cell deed contains his name.
Regard to exhibit 2A, my lord, the Jamabondi of where the Sunil Mondal's name is recorded has been described in the para 11 of the Manajat. Para 11.
This cell deed, second cell deed contains the name of Badal Mandal.
Sunil Mondal.
Only Sunil, only. Only
Exhibit
Sunil.
2 only Sunil Mondal.
Father of the person.
This exhibit 2A, my lord, 2A Jamabondi. This is of, my lord, this entry is of 1993.
No, you see, to understand a Jamabandi, you go to the land.
Yes.
The order of mutation contains the description of land as 1 biga, 2 gatha, 4 decha. From that, we are connecting this exhibit 2, that second cell deed. You see, come to page 42. About 4 lines, 5 lines from below. Ek kotha, ek biga, 2 gatha, 4 lesa. That's how we are connecting, not by the.
No, my lord, what I'm saying, my lord, the 72, that is 72, my lord, the cell date. That is not correspondent to 2A, my lord.
But then
That is not correspondent to 2A Jamabandi.
the page 41 cell deed.
That's
No,
why
one of these two, either 3 or 2, the 2A, one of them matches.
it doesn't matches because 2A is, my lord, with regard to these 2A is in 2A, my lord, name of the Sunil Mandal has been mutated as per, my lord, Sita Namjad.
Correct.
Yes.
But that doesn't take away this page
93.
41.
93.
No, whatever be. But there's a connection if it is, if that is the entry of with page 41, that is the second cell deed of 72. 72 may not help him otherwise to show his citizenship for the country, but it establishes the name of his father.
One Sunil Mandal was there, that must have been 72.
So if this matches, then father's name matches, then this 1968 cell deed confirms his father's name. And when this Sunil Mandal came and deposed in favor of the proceedee, this evidence has to be accepted.
Yes, here.
68, my lord, I doubt 68, my lord, my limited, my lord, understanding. My lord, this cell deed cannot be executed by him.
This is not a cell deed. First of all, you see the council who are even the present council and the council who was there in the trial, in the tribunal, did not read this document. This is a deed of exchange.
Yes.
Tafsil Khaw land is a land in Pakistan, East Pakistan, and they have made an exchange.
See,
So deed of exchange is permissible. And it is registered. Not only has produced the original document, it is shown to be registered. And this registration is a valid registration because this is one of the sale deeds which is executed in accordance with the manual of the sub registrar. Before the registration, the next page, third page, you'll find written in red pen. You've seen that. This is how it is required to be registered in according to the sub registrar's manual. Nowadays, they don't know how to use red pen and when to use a blue pen.
Come for hearing, my lord. It's
So therefore, you see, if you come to page 122, the tribunal comes to a finding at page 122, first paragraph. From the above discussion, it is established that the purchasers, including Sunil Mandal, who is the prosecuted father of the proceeding, were residents of East Pakistan till execution of Exhibit 1. Their possession over scheduled core land, meaning the deed was to confirm after handing over their land in East Pakistan to the seller of the said deed, obtaining permission from the so-and-so. And the execution of the deed does not establish the purchase of land by ordinary residents of India. So you see, even if that is discarded, their presence in 68 is established. Therefore, if not from prior to prior to 66, their presence will be there in the country in 68 to 71 stream. Because after that, there's a constant presence in the state. The land revenue receipt,
Yes, I have annexed that, my lord.
those shows that 77, 81, his continuous stay is almost shown.
Annexer 7A to 7F I have annexed also. It was also exhibited, lordship, in the tribunal.
now to link the petitioner along with the father. That must be. In the case.
হেৰিখিনি এইখিনি আপোনাৰ হেৰিখিনি এইটো কয় এই ৰেভিনিউ ৰিচিপ্টখিনি আছে, ভোটাৰ ৰিচিপ্টো আছে, ভোটাৰ লিষ্টখিনি আছে, ভোটাৰ লিষ্ট আছে আপোনাৰ 90 পৰা আছে, বাৰ্থ চাৰ্টিফিকেট আছে, গাঁওবুঢ়া স্কুল চাৰ্টিফিকেট, বাৰ্থ চাৰ্টিফিকেট আছে, স্কুল চাৰ্টিফিকেট আছে, বাৰ্থ চাৰ্টিফিকেট এনএক্স কৰিছোঁ আপোনাৰ হেৰি NXA 17 এক্সিবিটো কৰা আছে।
Stand in WS, my lord, something different from the, what, my lord, we have seen from the project case. Obviously, this subject is to be recognized that the petitioner's father is an Indian citizen.
Pardon me?
Standing by WS is totally different. WS, my lord, WS at para 7, my lord. 7 and 8.
Which page?
Page
Which
number
page?
79, Lordship.
Page number
79, Lordship.
79. Yes.
That Sri Sunil Mandal, the father of the proceeding, Anil Mandal, so and so, so and so, so and so. By religion, so and so, purchased a land situated in Bamungaon, Moja, so and so, from one original Indian citizen, namely so and so, so and so. And the registered sale deed of so and so, so and so. It mentioned that Sunil Mandal is an Indian nation of independent India, but due to poverty, he could not purchase any plot of land of his own name till
You're
1960.
reading which paragraph?
Para 7, mal.
7.
Second paragraph 7. Lordship.
Paragraph 7 of the WS.
Till 68.
Yes.
60.
So 68 he
Poverty, he
purchased.
could not purchase a plot of land. Matlab, be it mentioned
I
that Sri
will-
Sunil Mandal is an Indian nation of independent India, but due to his poverty, he could not purchase any plot of land in 1960. He has not admitted, my lord, he has coming from, they have come from, my lord, East Pakistan. Nowhere they have said that, my lord.
No.
That is in WS, my lord. Then para it is part of the, again purchase a plot of land on so and so. Para 9, my lord, it is more interesting. Para 9, it says the Sri Sunil Mandal, the father of the proceeding, has 3 brothers, so and so, so and so, so and so, and Sri Sunil left Assam about 35 years ago, and they settled in Calcutta, West Bengal. However, Sri Sunil Mandal and his younger brother Sri Badal Chandra Mandal have been residing in Bamunigaon, so and so, so and so.
Can you tell us the date of that sale deed? That sale deed is that exchange deed of exchange exhibit 1 is of which date?
68.
Just give the date. It will be very relevant.
This is Upopanjog on 7/11/68.
7/11/68.
Yes.
Now I will tell you something why this was relevant. This is a land which is in exchange in in Pakistan, East Pakistan then,
Yes.
correct? At that point of time, the Enemy Property Act 1968 was enacted, and it came into force on 10/7/1968. Correct?
Yes.
Therefore, what happened to that transaction, we don't know. Because the property in India, which has been exchanged with a person, what would be his status, we don't know. Therefore, we are not jumping into any conclusion. Because this land which was exchanged is in Pakistan.
Yes.
And therefore, there's a condition which says that once the land is, the exchange is complete, because that means the handing over of the land in East Pakistan would have to take place to confer title to the land which is covered by the Exhibit 1. And this is relevant because of the fact that of the date, 1968, 10/7/1968, this Enemy Property Act 1968 came into force.
10/11, madam.
10/7/1968. It came into force. Therefore, for that, the sale deed is, the deed of exchange is there. The law does not know how to read it. He writes deed of sale. It's not a deed of sale.
Yes.
It's a transaction which took place with a
The exchange
with a consideration of rupees 100. But then it is a deed of exchange. What happens to that? He abandons it. He does not know how to deal with it, and therefore this document is abandoned. Then comes 1972. So once 1972, in 68 deed, the father's name is same, Moran Mandal.
Sunil Mandal.
No, Sunil
Father-
Mandal's father is Moran Mandal. Therefore, once Moran Mandal is established, then all these three brothers or four brothers, their connection is established. And two of them came, his father and the uncle, came and deposed. That part of the evidence remains.
Yeah.
So whether the document establishes title on the land or not, we are not on that.
Yes.
It's a question of citizenship.
Yes.
For citizenship, 1968, the connection is made.
That is true, my lord. What my submission was, my lord, that in WS, what they projected, they did not project that the fathers and grandparents came from East Pakistan, exchanged
It's
the
not
land.
projected.
That is not there.
Projected.
Yes, that is not projected. That is the point I wanted to. That is not
No,
projected.
that would take away the title over the land.
Yes.
But
Their
that is not
projection
material.
Their projection is that they are original Indian, my lord. They are residing here. The father could not buy land prior to 68. In 68, he bought a land. That is their projected case. It is not that, my lord, they came from East Pakistan due to this reason and exchanged the property. They remained here. That is not their
That's
case.
not the case.
Yes, lord. Second point, my lord, the link. How they link petitioner link to the father of the petitioner, by whether it by way of any, my lord.
I have annexed the birth certificate of the petitioner also. So wherein my lord, father's name and mother's name is recorded also. It is when the birth certificate is my lord,
Page.
my lord, page number 59, lordship, annexure 10.
This will be difficult to accept because of the fact that you have not produced a copy of the magistrate's order. Once there is a delay of more than a year, then it must be registered only with the order of the executive magistrate or DM.
It is not exhibited also. Birth certificate is not exhibited. To link himself, he only exhibited a Gavra certificate and, my lord, the school certificate.
Marriage certificate of petitioner's father also, my lord. And school transfer certificate I have annexed also.
School certificate and Gavra certificate.
Exhibit 10 is the Gabra certificate, lordship.
And
Page
contact
number
certificate.
74, my lord.
Just a moment.
Exhibit 9, 10, and 11. These are the documents for linking herself to the father.
School certificate perhaps doesn't help you.
Yes.
My lord, headmaster was also examined, lordship, as PW3, lordship.
It was examined.
Yes, lordship. Annexure, my lord, 21, the page number 102, lordship.
School certificate is at page.
School transfer certificate, my lord, page number 72, lordship.
Page number
72, lordship.
72.
72 and 73 also.
73 contains the state emblem.
It's just 73 also.
It contains state emblem. It doesn't help you.
Is issued after 14 years of Malak.
We'll continue on Friday. This is both sides are represented. The submissions of both sides remains inconclusive. List on, make it Friday as a parted matter.
Kopita level everything. Mama kali din kayo.
Link I have sent you, Joy. Now this bench, right? No, new bench will sit. Our mother.
Yes, sir. Speakers went here. So it will go. It has both speakers. Okay.
Yes.
Please. Sir, I'll finish the rejoinder quickly.
Yes.
And I prepared a note so that I can go quickly through the rejoinder.
Yes.
That I request, my lord, the council, Debasmita, to kindly give the note to the court. My lord.
Yes, she has provided.
He has given it to you. Yes, my lord. If your lordship kindly turns to page 1. This is the video that I mentioned when I argued earlier. I would like permission, my lord, today to show the video to the court.
Video, we are not looking at it.
At all?
You have given us a copy. We'll definitely go through it, but we don't want a live telecast of it. This is
No,
also available in the.
Yeah.
This video will be available in the internet also. So therefore, no.
There are some parts of the video that I need to show and then explain what's happening.
So that can you'll have to show it here. You can come here and then show it in your laptop. But we are not making a live telecast of the photograph. If you want, we can refix it on some other day convenient to you. If you want
No,
to, then
I'll go ahead. I'll request my colleague Debasmita to actually show it to your lordship, and so that will not be live telecast in court. I'll do that, my lord. Now, my lord, I want to just make some points about the video. This is, my lord, paragraph 2. Kindly note, my lord. Everything is here in the note. Your lordship may not need to take any.
Yes.
The DGP's note says sophisticated arms and ammunitions were apprehended near Kaganagar, Part 6, while on way towards the Bhuban Hills in an auto rickshaw. During the search, one AK-47 rifle, one single barrel rifle, and one pistol was recovered, along with live ammunitions. And a perusal of the video will show the boys coming out, the 3 boys coming out of the video, wearing a vest. And you can see that they are being frisked. They are asked to remove their vest, show their chest. And you can see inside the the auto, and there's no ammunition, no gun at all, no AK-47 rifle, nothing. Then, my lord, they had no weapons at all and they were frisked thoroughly. That's paragraph 3. At 4, my lord, it is obvious now in paragraph 4, that's the video where, my lord, apparently the police, anticipating that these men were coming, had called their own camera crew. So it's important to realize that this is actually a videography of the police themselves. So it's not done by anybody else. And there, my lord, an attempt is made. There's a small pouch one of the men have. So this policeman puts his hand into the pouch. And you can, the cameraman is getting a glimpse occasionally. And one can make out that there's nothing in the pouch at all. Then, my lord, without taking out his hand, he runs and says, shoot, shoot, pistol, pistol, etc. So this is total drama done by the police. Total acting almost done by the police. Where, my lord, without taking out his hand he keeps in that small brown pouch. And he gets into a dialogue, which dialogue has been given to your lordship. That's at paragraph 5. So your lordship will see paragraph 5, the video goes like this. A person is saying video start. So it's almost like shooting of a film. And then, my lord, somebody says pistol, pistol, fire, start firing. They took a pistol out. And that is, my lord, entirely fictitious because the video shows nothing of the sort is happening. Shoot a video, they are using a pistol, etc. And then, my lord, whenever the cameraman tries to look or get a view of the pouch and what's inside, the police turn their back on the camera and block this cameraman from videographing the pouch. In any case, my lord, no AK-47, no rifle, no shooting, no pistol. The video is very clear and is very critical to the case. That, my lord, this video is shown and I'll ask my colleague, my lord, to show it. Then, my lord, from 7 onwards, the second video goes to a different situation where these men who have been caught have their hands tied behind their backs and they are kneeling or they are walking and with their hands tied behind their backs. And again, this is meant for the camera and for a kind of misleading the public. So they're kneeling with their hands tied behind their backs and the commandos surrounding them are saying, bring out the gun. There's no gun in the video at all. And there's no chance of him bringing out the gun because, as I said, he was kneeling. In that background, my lord, this dialogue takes place. This dialogue is all for the sake of preparing a text to mislead the court or whatever, to mislead whoever, my lord. The bottom of page 4, my lord, they brought weapons with them. And the video shows there's no weapon. And they certainly can't use it. Take out your weapons. But he's on his knees. Take out your weapons. Sir, they brought 2 weapons, but they're on their knees. Now, my lord, paragraph 8, if the videos did not exist, the transcription by themselves would mislead the public into believing that the men had several weapons. However, since the video is available, it is clear that the police are asking the men who are kneeling with their hands tied behind their backs to take out weapons which did not exist. The camera is put in position. The boys whose hands are tied are repeatedly out to take weapons, etc. Again, 9 is similar. Their hands are tied and they're walking. And the cameraman says they were firing at us. But the video shows no firing at all. And on the top of paragraph 10, the cameraman is reported as saying there are 3 rifles, but the video shows no rifles at all. That's why the videos are very important, because it's an attempt to fabricate a kind of a situation which doesn't exist. And thankfully, because of the video, we can make out that it was a totally fabricated kind of situation. Then, my lord, at the bottom of page 6, that's the fourth video. And there you can see, my lord, the police are saying, and this is captured by the cameraman, they shot our police personal's vehicle. Our people sustained injuries and were hurt. And at page 7, my lord, we get the stand of the police. The police were forced to retaliate in self-defense. Thereafter, we came to know that several of them were shot and had sustained injuries. Now, my lord, this part of the story on page 7, which I just read out, is completely contrary to the DGP stand. The DGP stand is, and this I had read out to you earlier, my lord, is that we caught them and took them to the area which was a militant hideout. And from the militant hideout, as we were walking with them in front, the boys in front, firing took place from the militant hideout, and that in the process of that firing, they sustained injuries. And, my lord, they died. Whereas here they say the police were forced to retaliate in self-defense. So the encounter was with the police, but whereas the DGP's note is that, my lord, the encounter was with the militants hiding. These boys were in front, so they got killed in that process. Now, my lord, I turn to the response to the arguments of the Advocate General. And, my lord, that is at para 12 onwards. I've already covered many of these points, my lord. I just want to deal with the, again, my lord, here, paragraph in page 10. Again, you'll find 3 lines from the top of page 10, loaded with sophisticated arms and ammunition, were apprehended near Ganga Nagar while on the way to the Bhuban Hills in an auto rickshaw bearing souls. And this is such an astonishing statement, totally false, because when they come out of the rickshaw and the cameraman videographs the inside of the rickshaw, you can see that there is nothing there. During the search, one AK-47 rifle, not there in the video. One single-barreled rifle, not there. Pistol, etc., etc., etc. Now, my lord, paragraph 14 is where, my lord, it is stated by, my lord, the prosecution that when these apprehended men were taken to look for the terrorists in the hideout, they were wearing safety equipment. But mercifully, again, we have the video showing that as they were walking up, they had no bulletproof jackets at all. Now, my lord, paragraph 16, I refer to the post-mortem reports, which I read out to your lordship in extensive. And the post-mortem reports were very well done, showing, my lord, torture, extensive cases of torture, extensive report. And the person, doctor doing the post-mortem, clearly did a very good job by pointing out to the areas of torture and so on. I'm not reading that because I had read out the post-mortem reports in detail. I'm allowed paragraph 16. Para 12 to 21 onwards refers to the post-mortem reports. The Advocate General merely read out parts of the report and made no comment on the submission of the petitioner that the post-mortem reports showed extensive and severe torture signs on the bodies of the deceased. All that the learned Advocate General said that was earlier the petitioners had sought the post-mortem to be done from doctors from outside the state. But once the petitioners received the post-mortem report, they gave up that demand. That statement, my lord, was correct. The Advocate General's statement was correct. When I saw that the post-mortem report was done well, I chose not to ask for or pursue the request that it should be done from outside because it was done well, and I concede that. And I say here the post-mortem reports were done meticulously. Now, my lord, the State Council could not give any explanation for the multiple marks of torture on the body. Because if they were taken up the hill to search for militants and they opened fire, then certainly they'd be killed by gunshot injuries and not by, my lord, any torture and so on. The torture is a clear sign that it had nothing to do with the encounter. And I'd also argued, my lord, that the observation in the post-mortem report of blackening around the entry wounds in the head is a sure sign of carbon black being deposited, which means that the weapons were fired at very close range. Then, my lord, I come to the paragraph 18 is the so-called magistrate's report. This is, my lord, the executive magistrate, and he is, my lord, the Joint Secretary Government of Assam. He has made the report. And there are two big observations, main observations that I want to make in support of my submission that the magistrate's report needs to be, my lord, discarded in toto. There is not a word about the video. So the most critical part of the evidence showing what happens is missing from the magistrate's report, is ignored by the magistrate. And the second most important part, which is the post-mortem report, is not even referred to by the magistrate. So it almost appears as if the Joint Secretary Government of Assam has neither seen the video nor seen the post-mortem report. Now, on paragraph 19, I make the argument, my lord, if the DGP himself had supported the killings of these three men, and he makes statements to that, applauding everyone for having done a good job of killing them in an encounter, then it is difficult, my lord, to expect that the Joint Secretary will do anything to the contrary, apart from saying that it is a genuine encounter. So it's not a report, my lord, that gives one any confidence that it was an independent and technically, scientifically done report. Similarly, the Chief Minister tweeted the same position, and it's set out, my lord, in the petition and the rejoinder. So, my lord, in respect, then, my lord, we have at paragraph 21, the statement of that this is the prosecution stand that 3 police persons suffered injuries. And, my lord, we look at the injury reports of these 3 police personnel, which is paragraph 21. The first report is at page 21 of the third affidavit filed by the state, dated so-and-so, shows that in respect of police person so-and-so Rongmai, the injury suffered was simple injury by blunt object. Then, my lord, paragraph 22, in respect of police personnel Ajmal, the medical report at page 22 is farcical because it says that the injury is grievous, but at the same time on the same page it says soft tissue injury of back. Obviously, this is a simple injury, certainly not grievous. In respect of the next policeman, ASI Dilwar Hussain, this is at page 20. The injury report says bruise. And, my lord, in respect of Ajmal at page 24, the injury report says abrasion. Then, my lord, paragraph 25 of the counter affidavit says one accused person had a criminal record. This I pointed out to your lordship that the name of this person and the name of the person who had the criminal record, the first name is the same, but the father's name is different. So obviously that the criminal record of that person cannot be attributed to me. This has been dealt with by the petitioner at page 145 of the rejoinder, and is a simple mistake made by the state by mixing up 2 similar sounding names, but they are different persons having different fathers. The case law, my lord, I won't mention again. The case law is set out at page 146. And this is all the case law where the Supreme Court has said that in cases like this, where the police themselves are suspect of killing the persons concerned, it should be an independent person an independent head of the SIT, and the SIT should be of officers from outside the state. That is all, my lord. I finish my rejoinder. I'm grateful to your lordships.
Since you are taking it up after a long time, you're refixing it after 2 weeks. If you have any queries, we'll put it.
Please, madam.
Rebuttal will not be required because you have, it's only a reply. Reply against rebuttal, then we again, it never ends then.
Yes, my lord. Even for me, I thought my region may not have been so. But I put everything on record. My lord. That's. I'm grateful for the patient hearing. And
No, we don't know. We are not making it in the order. We'll see when it comes because for against rebuttal, it becomes very difficult to handle. The submissions in reply by Mr. Colin Gonsalves, London Senior Counsel, assisted, who appears through video conferencing, assisted by Ms. D. Ghosh, London Counsel for the petitioner, is concluded. Mr. D. Nath, London Senior Government Advocate, along with Mr. H. K. Hazarikar, and the Government Advocate is present. Oh, you are also there? Yes. Ms. R. Barwa, along with Mr. R. Barwa, present. Next paragraph. As the matter has been matter has been heard after a long gap, list the matter on 9/6/2024 for clarification, if any required.
grateful.
9th or 10th? It should be better. 10th then. I should just say, Mr. Gonsalves has made his reply submission and he has handed over and Ms. D. Ghosh, London Counsel, has handed over a written note of submissions, which is kept as part of record. Okay.